Happy winter, Brisbane. I am Chris Irons, former Commissioner, Body Corporate Community Management, Strata Adviser with Hynes Legal, and with me always, Frank Higginson, partner, Hynes Legal. Frank, welcome.
Hello, Chris. Hello, everyone, yet again, including...
a special shout out to our regular viewers, some of whom we met in person last evening at a function. Very nice to meet you, and thank you for the lovely comments as well. That was really nice. Yeah, I know that the people we met aren't actually watching live today because they've got a couple of other things on, but they will definitely be watching later, they assure me. Yeah, thank you. Appreciate it. As always, please remember to register. That's how you'll get notification. We'll have our June, gosh, it's almost the end of May, Frank. We will have our June webinar topics out shortly. We've already given a little bit of thought to those, and of course they'll be good. That's where you will actually,
if we say so ourselves.
Yeah, that's where you'll actually find out about them. Throw some questions or comments into the chat feature as well. We'll try and get to all of those today. We've got one already. Well, Sandra, thank you for your question. We will get to that one. Today, Frank, sequel time again. I guess it's good that we're getting a lot of sequels out of these. I mean, it's clear that there's big topics that require a bit of work to get through.
Absolutely, and I think sometimes we're a little bit optimistic in terms of half an hour even covering some of these issues. I mean, yeah, it's one of our third for some of the management rights ones. So yeah, that's
very optimistic, I think. Today it's part 2 of our challenging person facilitation product, service, whatever you would like to call it, that Hynes provide and that I primarily lead here. And it's fair to say that the one we did back in April, and I'll chuck up a link to that in a minute, the one we did back in April is probably one of our best attended webinars that we've done recently. In fact, the only one that's probably had more is that hour special that we did on the new regulation modules. So I've just putting the link up there. Now you can find it on our website and also on our YouTube channel. I guess, Frank, the obvious answer out of that is that people want to know more about challenging people, don't they?
Yep, absolutely. And I think in that one we sort of covered really probably a fair bit of what you do, and we'll talk a little bit about that today. But also then it's the plan B. If it doesn't work, what do you do legally? And I suppose that might be a little bit enlightening for some people in the sense of not as much as you might otherwise think that should be available. But we'll get there.
We all get there. So we're going to cover that one, and we got a specific query last time as well about what to do when you have a person who produces a significant volume of adjudication applications. We are going to address that point a bit later in today's webinar as well. Before we get to that, a couple of thought-provoking comments, I think, for people, Frank. That's how I would term them. I want to pick up on one point that was raised in the last webinar. It's something that you and I experience on a pretty much a daily basis, Frank, and it's that sense of helplessness and victimhood that people come to us with, particularly in the context of dealing with a person who is challenging. And what do we mean by that? We mean that even though you or I might talk to somebody and talk through pros and cons and processes, we are confronted with a range of comments, and they're usually along the same lines. It won't work, or no one will help us, or the legislation is stacked against us, or the one that really sort of sticks out for me. So you're saying there's nothing we can do about it. And look, it's very frustrating to hear those things. I do understand, Frank. I think we both understand why they get said, don't we?
Oh, it is, because it's potentially, well, it's months, probably years of frustration, of annoyance, of pain, and probably trying to do things and not actually getting anywhere. So more than anything else, it's a sense of frustration. I've tried everything and now there's nothing I can do. And that's part of, I mean, what we're talking about today. There is something you can do. This is what the facilitation process that Chris runs is actually all about, providing solutions, because the legal ones aren't necessarily there.
It's intervention, and that's precise. That's literally what it is. And so I suppose one of the messages we want to send today is that while we get 100% why a committee or other people would feel a sense of helplessness or a sense of victimhood in dealing with a challenging person, it's really important to try and find a way to step out of that mindset, because If you keep reinforcing to yourself that nothing can be done, then nothing will get done. That's just how it is. If you keep reinforcing that negative, it won't change. So and you need to remember that you're in a situation not by your own design. This did not happen because you chose to be in this situation. You're in this situation because you purchased a property. And in doing so, you purchased a whole bunch of rights and responsibilities that go with it. Now you are dealing with those. Now you're transacting in them. Now you are enforcing them. This person who's posing a challenge to you is doing so as a product of the situation. So you've got to think of it less about helplessness and victimhood, if I can put it that way, and more as a product of circumstance. The second thing I want to quickly raise, and we've talked about this a lot in recent webinars, Frank, is this idea about a body corporate being about running a business and about the relationships within a body corporate being transactional in nature. And so I guess we want to make this point to people. People's obvious response to this discussion and products and services we offer is, well, we just can't afford that. Fair enough. Let's put it this way, though. If you accept that running a body corporate is running a business and that you are involved in transactional relationship, then you need to actually spend money to resolve it. Wouldn't it make sense to do that, Frank?
Absolutely. And I'd still, I suppose, we understand professional services. When we have legal issues that come up in our business, it's that old adage of the person that acts for himself has a fool for a client. We have a couple of people we use for legal issues that we face. So I've got a really good commercial lawyer when you sometimes have things from left field. We've definitely got a really good workplace relations lawyer because that stuff is terrifying. We use accountants to give us accounting advice, and we pay. So in theory, you'd think we've got 9-10 lawyers in the office. We specialise in strata. It makes business sense to engage people that know what they're doing to give you advice about the issues that you're not necessarily sure about. And it's still, I do get it. And some of the committees, we've put this proposal to, but the owners won't want to spend any money. And my response to that, to those committee members, is why on earth are you going to put yourself out as a volunteer to act for a whole bunch of people and cop this grief? It just doesn't make sense. You know what I mean? So yes, you can be a martyr for the cause. And this is, of course, talking to people that have been traumatized by what they're going through. And at that stage, they potentially can't see the forest for the trees. But it is not an unreasonable position. And I think it's an eminently sensible one to actually, and of course, it's a very subjective thing, but don't pay us. Go find someone else to help you as well. It's just get this monkey off your back by engage someone who can help you figure out what it is you should be doing.
Now let's talk about perspective on that point.
But
but let's talk about perspective on that point for a minute, Frank. You've spent 600 grand, probably even more, on your lot. That's not including the money that you contribute via your levies to maintain the common property and therefore maintain and grow the value of the property as well. So we're talking more money. To be perfectly frank, the percentage of that you might spend on our services is pretty small in comparison.
3/8, absolutely. And that and this is only the money. We're not talking about the time and the emotional cost. Those emails you get and your gut clenches, worst things forever. The phone number comes up on your phone. The text messages.
We have that, Frank. You and I have had that. We continue to have that. I had it as commissioner. All right, I can tell you. The point being, let's get into this mindset of body corporate as a business and as transactions, and then you can actually start to treat this difficult issue as a business issue that requires a business solution, which is what we've been talking about in part 1 as well. So we just wanted to make those couple of points to people today as well. But let's go back to point 1 that we wanted to cover off today, Frank, which was what happens if the challenging person service doesn't work or you think it's not working. Well, let's challenge that idea. First of all, we're all into challenges today. Let's challenge it. Let's challenge
last night, challenges now.
Let's challenge the idea that it hasn't worked. And I guess you've got to begin with, well, what were your expectations to start with. And I'd say to people, if your expectations were that you would have a warm, loving, fuzzy relationship with the challenging person forever after, that's absolutely the wrong place to start with this sort of thing, isn't it, Frank?
It is, and this is back to that business relationship element, and I think you've said it a lot about committees and resident managers in terms of you don't need to be best friends, and in fact, you probably shouldn't be. Doesn't hurt if you are, but the whole we need to be best friends with our fellow co-owners and all that sort of stuff is also a bit of a fallacy as well. A body corporate, by its very nature, is created by law. That in itself doesn't make it a social relationship, it makes it a business one, because you're all tied together in this thing with a bunch of corresponding commitments and obligations and rights and all that sort of stuff. And you don't need to be besties. And so in that sense, it's coming back to, and you might even say it's from like a legal perspective, like we deal with lawyers all day, every day. And of course, in the strata space and the management rights space, we deal with a lot of them more frequently than others. And who knows, at any given point in time, we might have 20 matters on with different people at another law firm, some of them similar, some of them not. We're not friends with them. We might socially see them around and about. Some of them might have used to work with us even. But that doesn't mean that we're unfriendly. It just means we're professional, and we do our job, and we get the business done for our clients the way we need it done, regardless of who it is we're actually acting for. And in a body corporate sense, that is not dissimilar.
Yeah,
I agree, and particularly we're in a committee hat. A lot of owners obviously have a little bit more flexibility. If they're not on the committee, you've got some overriding statutory obligations around acting reasonably and all that sort of stuff. You're really a custodian of other people's investments in terms of representing their interests, the collective interests of everyone, of which yours is one. Some decisions you can make, others that you need to go to general meeting, but you're really the guiding light for that body corporate. And that's that hoping that we can all be besties is a utopia that just won't ever happen.
Yeah, in fact, I'd go a step further and say, Frank, your correct expectation about this sort of stuff is not for that, but your correct expectation about challenging person facilitation is line in the sand, making a clear statement about what will and will not be acceptable from a certain point into the future, and incremental, and by incremental we mean very incremental improvements in not so much the person, because you can't change a person, but incremental improvements in the way in which the relationship pans out and its impact upon you, both in time, money, and also emotional terms.
And being completely selfish about it, it is about the impact on you. If you're watching this webinar, it's clearly, you would think you're interested enough in it, or there might have happened to you in the past. It might be happening to you right now. There really is a degree of sort of personal care that this thing's actually about. And that's the volunteers that are committee members that are probably on the receiving end of lots of this stuff are the ones who keep going through it.
Absolutely.
And keep dropping it.
So I think the first point, if somebody says this isn't working, then we need to say, are the expectations set correctly at the outset? A couple of other things that we need to sort of challenge about that comment: is it not working? Has the process been given enough time to work? I mean, I think, Frank, we say a minimum 2 months for it to start to show results. I reckon it's considerably longer than that.
And it's probably a little bit proportionate to how long it's been going on for. If you've got 3 years of consistent behaviour in a certain way on everyone's part, then expecting that to change overnight, and overnight in a relative sense is 1 month or 2, is probably not realistic either. You've got to be committed.
Yep. The next point, have you actually followed the framework that has been agreed to, set out and agreed to? That's another point to challenge. Point that might be a bit controversial, but I'll make it anyway. Are you actually really engaged with it? Because my experience, any process, not just this one that we're talking about, challenging person facilitation, but any process that people embark upon to change the nature of a relationship, Frank, unless you are actually committed to it, it won't work. And the reason for that is because your lack of commitment will show through, ultimately. It will become obvious that you're not committed to it.
And probably these things do require change on both sides. Some of it you're in control of, because some of your behaviours, right, wrong, or indifferent, might have been encouraging, fostering, allowing, or otherwise participating in this same stuff. So you've got to maintain that course as well. And if you don't, then you revert to the mean.
And probably one other point to make, I use a lot of standardized mediation techniques in this kind of work. And it's not uncommon in mediation for there to be more than one mediation session needed to resolve a few points. So again, just remember that it's not just a one hit and done kind of thing.
Wave the magic wand. And
it's a process. So look, with all of that in mind, if it really hasn't worked, where do you go? Well, let's have a look at that. First thing I want to bring up, and I think I've talked about this in a couple of other forums, Frank, and I know that this is a topic that comes up quite a bit, is this idea of capacity. If you're dealing with somebody who's a challenging person, maybe they have some capacity issues. And by capacity issues, and I don't profess for a minute to be an expert in this field, but in my limited experience with it, capacity is about somebody's ability to make a proper decision, isn't it, Frank?
Yeah, competence, I suppose.
Yeah. So are they suffering a medical condition that makes their ability to make a decision valid? I'll give you an example from my time as commissioner, and I'll de-identify this one as much as possible. I got a call one day from the senior sergeant of a small police post in Queensland, and he said, "Oh, look, I just want to ring and touch base with you about this particular person. I understand they've got a matter with you at the moment. Can you just tell me where that's up to?" And they identified themselves appropriately, got their number, all of that sort of stuff, and I was happy on that basis to do it. And then they told me that that person they had to pick up in their local community several times because they were wandering around aimlessly, not knowing where they were, not knowing their name, not knowing their address. And yet this person had apparently signed their name to documents that had been lodged with my office. So to me, that was a very clear example of a serious capacity issue with somebody affecting a body corporate matter. That's probably an extreme example, but it's an example nonetheless. There are ways and means to go through that process. In Queensland, it's the Office of the Public Guardian, which is your first port of call if you have concerns about an individual's capacity. And one of the advantages for a body corporate in that respect, if somebody doesn't have capacity and they have somebody else assisting them in decision making, whether it be a family member or practitioner or somebody else, you can deal with them because they are authorised to make decisions. And you might find that to be a far simpler exercise than dealing with the person. Yeah. Then we get to, sorry, Frank, go ahead.
I was going to say just the legal options then really, which is, I suppose, lawyer territory, which is what we're trying to leave as a last resort. So, we get bullying thrown around a lot. The reality is that in a pure legal sense, the only person that can be bullied in a strata situation is a resident manager who is accompanied by a committee. So, Chris, I put a link in there. You might want to post up newsletter that we did, and there it is there. That's it. So committee members can't bully other committee members. Lot owners can't bully a resident manager. Resident managers can't bully committee members. So bullying is very limited. And the reality is with bullying is there's no damages awards and that sort of stuff. What proceeding in the Fair Work Commission produces is an order to stop the behaviour that is bullying in nature. That's it. So a lot of those don't get run. You could read that case there, which is an interesting one. Then I suppose you look at probably action under the legislation. So there's probably two scopes for that. First is section 167, which is a proceeding to seek an order that someone stop being a nuisance, which is the word we don't use anymore in these conversations. But that nuisance needs to be coming from a lot or a common property. So, Chris, I think, again, you would have seen a bit of this in your time. If someone's screaming at people as they walk past their front door, then quite clearly, evidentiary-wise, that's happening from the lot.
And there have been orders made along those lines, yep.
If someone's sending emails, where are they coming from?
Could be coming from literally anywhere. And I think there's actually been adjudicators' orders where the adjudicator has made that very point. It's almost impossible to prove that an email is coming from the lot.
So
or the
next
lot
level
being used.
Yeah. So next level for that is then potentially a enforcement of bylaws. So the starting point is you need to have the right bylaw that deals with nuisance again or challenging behaviour. So that might be a bit more specific about emails, communications, correspondence, and all those sort of things. So for those of you that don't have that bylaw, we've got a process on our website. You can send us your CMS. We send you a free quote, and dead set, every single set of bylaws we see doesn't have the right bylaw in relation to nuisance. But that then is not necessarily a proceeding straight to adjudication. That's a proceeding in relation to issue of a notice of contravention of bylaw and following through, seeking orders that be dealt with. And at the moment, in the Commissioner's office, it's probably taking somewhere from, because that's something that get conciliated every time, wouldn't it, Chris?
Yes, it would.
Those sort of conversations. So you've got to go through the conciliation process first. Then if that doesn't work, you've got to go through adjudication. And at the moment, we understand that's about an 8 to 9 month process from filing to conclusion. And
you've got to do that properly as well, because if it's not done according to the prescribed process, you're back to square one. A couple of other things. If the challenging person is on the committee, you can always seek their removal. That's open.
If we spoke about that a couple of weeks ago, didn't we?
We did.
Getting off committees.
I did. If the challenging person is a tenant, then you might want to have a chat with the managing agent, but you also might want to have a chat with the landlord, the owner of the lot, just to make sure they're aware of what's going on, and also remind them of the time and cost, because they are actually contributing to costs in the form of their levies. So if you as a committee are having to spend money in dealing with a tenant who's a challenging person, the owner of the lot who has the tenant in their lot, they will be meeting that cost somewhere. So you need to make that point, I think, very, very strongly to the landlord in that case.
Just be very careful about being defamatory.
Yes, very much.
So,
very much.
Not emotional words. That's the way to do it.
Yes. Look, if the challenging person is the on-site manager, then there are performance management actions that can take place, and we've gone over a lot of those in recent weeks.
And I think we've got another webinar to come on that too, so that'll be next month maybe.
We do. If the challenging person is a body corporate manager, then you take up a complaint with them, with their company, and if they're a member of the SCA, you can potentially take up a complaint with them. If that seems like a short list, well, that's because it is. The legislation, let's be honest, Frank, it is woefully ill-equipped to deal with this issue, and it doesn't arguably deal with it at all.
No, no, is the simple version. In terms of the range of issues we have come across our desk, and look, because everyone's different, and this is, again, I'll give you credit for it, mate, you're the first one to say it, you're never ever going to be able to regulate human behaviour. And that's what all of these issues are. So you might have a word nuisance, but in terms of the issues that we see coming across our desk in terms of people's behaviour, they are extraordinarily wide. You're never going to be able to drill down on all of the sort of detail. So, yeah. And who knows, maybe when this, certainly there was nothing about this in BUGTA. So BUGTA was our legislation from 1980 through to 1997. BCCM introduced some of these provisions, but I think probably even when BCCM started, it was back to bodies corporates having committee meetings on the driveway with some tea and bickies, and now they are bloody big businesses.
And I think increasingly government's going to have to turn their mind to it, Frank. In this current reform process that's underway and that you and I are both involved with in different ways, it's going to have to be addressed
and
somewhere.
Before social media and before emails.
Yep.
This legislation was drafted, which has changed the landscape completely in terms of communication.
Very much so. We've got only a limited amount of time left, so I want to really quickly touch upon this point about that was raised previously, and a couple of questions there that we're going to try and get to as well. But this point about the filing of a lot of adjudication applications, and we hear this a lot. You can't stop somebody making an adjudication application. There is no such thing as a vexatious litigant in the Commissioner's office. The only option is that an application is dismissed as being frivolous, misconceived, and vexatious, and then costs might be awarded in that case. I'm just going to throw up a few links here. Frank, do you want to just talk about this briefly?
Yeah, it's
while I do
interesting.
that?
So there's actually a specific piece of legislation in Queensland, Vexatious Proceedings Act. So that really, as best we could tell at a quick look before, and it's interesting, the Courier Mail and Sunday Mail have been running a couple of articles on this. There's been 27 people declared vexatious litigants in Queensland since 1983. So probably 8 a decade. And you'd appreciate there's who knows how many thousand legal proceedings, or probably tens of thousands of legal proceedings have been filed across all of the state jurisdictions over that period of time. So even at court level, it's a very, very, very high bar, because, you know, you come back to the core of the legal system, and this is what it's about, is courts are there to allow people to enforce their rights. So removing someone's ability to access the justice system in itself is a very, very big stick. So what a vexatious litigant needs to do is they need to make an application to the Supreme Court to be able to file a proceeding in that same court, or in fact any court in Queensland. So it's an oversight. You've got to come to us and you've got to explain to us what it is before we're going to allow you to charge on, because obviously people get put to the expense of defending them. So there's no such thing in the Commissioner's office. And, you know, this is one of those things. It's people might file proceedings all the time, and some of them do. And Chris, you've probably got a couple of examples that you will remain nameless. But even if that proceeding has some element of truth or accuracy or breach of, that's a lawful proceeding. So if you look at, I think the one that Chris has just posted, the very last one there, which is a judgment from Walter Sofronoff. It's about gobbledygook. Basically, this guy's proceeding was so off the reservation it wasn't funny. And basically, you're the next one, mate, so you can't file another one unless you come back and ask us about it. So there was not a single element of basis for it in any way, shape or form. And in the Commissioner's office, in terms of, you know, breaches of legislation and all that sort of stuff, it's very easy to get things wrong. Not in the Commissioner's office, but I should say in terms of interpreting the legislation, dotting every I and crossing every T, it is difficult.
And it doesn't happen a lot, and the adjudicators do give people a fair bit of leeway with that sort of thing. They'll usually give them a couple of warnings about their application being off the reservation. I like that one, Frank. But yeah, one thing I would say, I personally support the idea of some kind of vexatious threshold in the Commissioner's office. I don't think that office should be dealing with some of the things it is currently obliged to deal with. That's number one. Number two, the amount of costs which can be claimed for those kinds of applications, the limit should be much higher than it currently is. Currently, it's $2,000. That doesn't touch the sides, does it, Frank?
No.
No.
No, not really complex ones at all.
No. But prevention is obviously the best form of cure here. And very quickly, one of the other things, again, the hip pocket solution to this. There is nothing wrong with letting all the owners know just how much money the body corporate is having to spend to defend an application, if that's what the case is. And again, as Frank said before, it's about how you present that information. But there is nothing wrong with simply notifying owners, we are spending this much on legal fees to defend this matter. You're paying for it, everyone's paying for it eventually. We have a couple of questions there that I want to get to. Sandra, this one isn't really about the topic, but it kind of is. You've asked for some information about owners who individually engage tradespeople for common area repairs without the committee's approval, then table the invoice for payment. What to do? Well, don't pay it. Maybe is the start point.
Absolutely.
Let them dispute it afterwards. And Frank, you found something else as well?
Yeah, well, Section 310 of the Act gives people who are third parties protection, I suppose, in the context of if they're dealing with committee members give them instruction to do something. They're not obliged, that third party's not obliged to go behind the scenes to make sure the resolutions are in place and all that sort of stuff. But that only applies to committee members. If lot owners are running around instructing tradies willy-nilly to do things on the pool, and the tradie doesn't check out their authority to actually do it, then that's their problem.
And Sandra, I've just put a link up to that section there down the bottom. Ian, thanks for tuning in. In previous sessions, you've spoken about lobbying for change. However, for a loan owner to lobby, they need access to the owner's role. Should all owners have access to this document? Well, Ian, it's not a case of should. They do. They do. it's enshrined in law that they have access
And
to the role.
This came up last night in our seminar we did. There's no such thing as the Privacy Act so far as it relates to owners accessing other owners' information off the body corporate role. And now that includes email addresses. So that is absolutely 100% available to you.
And then from Tim, thank you. Regarding just a good observation, I think, regarding a capacity, consider also skills. Need to remember that appointment to committee positions isn't necessarily based on expertise in managing property. And you're absolutely right, Tim.
It's based on this.
Yeah,
I'll do it.
Or it's based upon that, which is no, you do it. So you're absolutely right, and this goes, I think, to the point that's been raised a couple of times, and I know I'm really coming around to this idea, Frank, of there being some minimum standards for committee membership in Queensland.
Or it's the non-executive member who's sort of almost a professional committee member, and this is one of the pushbacks has always been cost, and it was one of the discussion points. The very last reform paper is, should there be professional committee members for schemes above a certain size? In a lot of respects, it would be helpful because you've got someone independent, not emotionally involved with the outcome of the decisions, giving the body corporate some advice. And again, that's a person who acts for himself as a fool for a client.
Absolutely. Our final link, we've gone a bit link crazy today, but our final link today is a link to our webpage about challenging person facilitation. So more details there on the service in that final link we've just popped up. We have run out of time, Frank. Phew, gosh, really sprinted through that one today. We covered a lot of ground, and I think there's a lot there for people to absorb. So please do that and then come back to us afterwards. There's a bit there to take in. And I know a couple of things that we said might be a bit forceful or sort of a bit provocative, but I think that's what this topic needs.
It's
frankly.
reality testing. Like, you know, again, if we had a magic wand and we could wave it, we would, but we don't.
No.
So these things, they come about over a long period of time and they take some time to unwind. And this is really what Chris left the Commissioner's office for, is to do these sort of things, because it's right. We are doing ourselves out of work as lawyers. And I'm quite happy to say that, because otherwise, before this offering, product, whatever it might be, your only choice was going through a bylaw enforcement process. And 12 months later, you might get an outcome because you've got to go through the bylaw breach process before you even file anything in the Commissioner's office. So that's just not realistic. There's better ways to solve these problems. So if that's all you've got, then that's actually not a pretty place to be. But there is a real alternative with what we're talking about today.
We think there is, yeah. Really quickly, Ian, back to that question about the role, who should provide access? That's a committee decision. Ian, committee decision.
But in the sense of, you can go and inspect the records and get it yourself.
Yep.
No one's entitled to deny that to you.
Yep, that's right. Thank you, everybody. As I said, covered a lot of ground there. Really appreciate the engagement that everyone had today. Next week, just decide, God damn it. Until next week, Frank's disappeared. Frank says goodbye. I say goodbye as well. We'll catch you then. See you.